Thank you, Anthony. You can go to lawandcrime.com to learn a little bit more about those stories and other stories that we cover in the political realm, the entertainment realm, and of course, the legal realm. But let's talk a little bit more about that really horrific story that you just heard about, a husband killing his pregnant wife. And to help me talk a little bit more about it, I'm here with criminal defense attorney Randy Zelin. Randy, great to see you.
You too, thank you.
This story is not a good one to start the day with, but my gosh, this guy confessed to doing this?
Apparently, he did. And of course, one of the critical pieces of the case is whether or not that confession is believable, the circumstances under which the confession was made. Viewers may be surprised or perhaps not surprised to learn that there is such a thing as a false confession. So that's one issue that is certainly going to come up. And then, of course, there is this notion of, based upon that confession, is it possible that the case gets taken from a murder one, the premeditation, and becomes more of a heat of passion, which gets you closer to manslaughter and certainly a lot less exposure from a sentencing perspective.
Now, you're saying that because, based upon the story that we've heard so far, he said he killed her because she disrespected him. So you're saying maybe perhaps there was a fight that broke out. But isn't that kind of tough to do if he really is, implicated in the death of her father and her? I mean, those are two victims now. Wouldn't it be tough to say that this is not a premeditated murder in both counts?
Though, by the same token, what you just created was an appeal issue. Whether or not it is fundamentally unfair to try both of those cases at the same time, absent really being able to link those two crimes. Because the one thing that we always want to avoid doing when we are on trial from a justice, the system of justice's perspective, you don't want to convict someone based upon a propensity. In other words, if I think he did this crime, then he must have done that crime. Now, that most often comes up in a situation like, for example, in the Bill Cosby case, where Mr. Cosby was charged with this one particular crime, but then a whole bunch of other women were permitted to come in, even though he wasn't charged with those crimes. They were permitted to testify about his criminal conduct towards them. Ultimately, the appeal issue will be there. Okay, was Bill Cosby convicted based upon the testimony of the victim, who's actually the complaining witness in the case, or was it based upon all of these other uncharged crimes? You don't want to convict someone by a propensity. So, bringing the case now to your story, the story that we're talking about, is whether or not this particular person is deprived of a fair trial because now you're taking two crimes, lumping them together, and having the jury hear about two crimes within one case.
Unless they can, and correct me if I'm wrong, they can somehow link him to the evidence from one crime shows that he committed the other. I mean, we're covering the Marine killing case where two defendants, Quincinio Canada and Dewan Mulazam, they're saying that this gun that was taken at a robbery, at a hotel robbery, was then used in connection with the shooting of Jonathan Price. So if the prosecution in this case out of Florida can tie evidence from the father's death to the daughter's death, that might be an exception.
Absolutely, but it's interesting because in the Marine case, it's actually the defense is using that prior crime. It's actually the flip side of the coin, where typically the prosecutors are thrilled to have this other crime as evidence of the charged crime. But here, the defense is going to come in and say, wait a minute, that prior crime, you have bad identifications. It wasn't us. In fact, the gun that is really the only piece of evidence that you have that ties the two cases together. You may have the gun, but you have problems saying that it was my hand that was on that gun in both of those cases.
Final question about this Florida case. Is it possible that he could be charged with the murder of the unborn baby?
That is a very interesting thought, and that really marries, I think, at some level, the definition from a medical standpoint of when life begins. Now, there are certain statutes that talk about charging the death of an unborn fetus, and then, of course, we can get into the religious and, again, the scientific debate over when life begins. Is it at conception? Is it at birth? Is it somewhere in between? And as horrific as it is to be clinical about it, the reality is they have more than enough evidence with regard to those victims where it is beyond any question, religious, scientific, medical, or otherwise, that they were human beings.
Yeah. Yeah, you said it right. It really is a horrific case, and we're going to cover more of it here on Law and Crime as soon as we have an update about it. But Randy, stand by. We want to switch gears here and not go into the murder or the sexual assault or the kidnapping realm. Let's go into the realm of public corruption and really greed. Here, we're going now to North Carolina, and we're talking about the Wallis Bradsher case, a bizarre case where 2 district attorneys are alleged to have entered into this criminal conspiracy to hire each other's wives, which isn't illegal in itself, but Wallis Bratcher, the defendant right there, is accused of hiring this other district attorney's wife and paying her $48,000 for work she didn't do. That is stealing taxpayer money, ladies and gentlemen. So yesterday was very interesting. Yesterday was the conclusion of this case. It is when the defense, Wallis Bratcher, who's representing himself, as well as the state, had an opportunity to present their closing arguments to the jury in their last attempt to provide their narrative of what the evidence shows. I want to play for you right now some of Wallis Bradsher's defense's closing argument. And this is important because he opted not to testify. And we've talked about it here on the network, that perhaps this closing argument was the last attempt by him to explain his version of events. Let's play it for you right now. That is Wallis Bratcher, the defendant, literally fighting for his life. He faces up to 18 years in prison if he is convicted of these crimes in connection with this criminal scheme to defraud the people of North Carolina. Let's talk a little bit more about it here with Randy Zelin. Now, I'm going to ask you the question that I've asked everybody I've had on here. If I'm sitting on the jury, I'm confused what his incentive is to be a part of this scheme. It's not like he earned $48,000. It's not like he retained a benefit of it. It's basically he is fighting his 2 accusers, Cindy Blitzer and Craig Blitzer, who ultimately benefited from getting the $48,000, even though they ultimately had to return it. But that's where, if I'm sitting in the jury, why would this guy make such an effort to make sure that Cindy Blitzer didn't resign, that he tried to cover it up, that he said he had unfettered discretion to do what he wanted in the office? What am I not getting?
You may not be getting anything. And that may be what one juror, because you only need one juror to say, I need more information. What is the definition of reasonable doubt? The definition is simply whenever you have to make a very important decision in your life, do you have enough information whether or not to have surgery? If you have enough information to say, go ahead, schedule the surgery, you do not have a reasonable doubt. Conversely, if you say to the doctor, you know what, I need to talk it over with my wife, my husband, I'd like to get a second opinion, that's reasonable doubt. Now, what's interesting with what you just said, that's not necessarily an element of the crime. But it's a very weird thing that we do with jurors. We say to a juror sitting there, before we, as a lawyer and as a judge, say you can sit on this trial and sit in judgment of this defendant, what do we ask of the juror? Number one, will you promise that you will follow the law, whether you like it or not, whether you agree with it or not? Will you promise me that you will follow the law? But at the same time, we say to that same juror, all we want you to bring into this courtroom is your common sense and your everyday life experiences. Those two things immediately are in conflict because, to your point, what juror is not going to sit there and go, I don't get it. Mm-hmm. What was in it for this guy? And not care that the judge, when the judge gives the jury instructions today, nowhere in those jury instructions does the prosecution have to necessarily prove that Bratcher was getting some economic benefit,
right,
some financial benefit. So what is a juror to do? Well, invariably, a juror, because it's got to be unanimous, you only need one to say, you know what? No, I don't have enough information.
And maybe that's what will happen. You hear Bradsher in his defense's closing basically saying, appealing to their common sense. But I want to play you right now what the prosecution had to say in their closing argument. And as you can imagine, it was radically different than what Wallis Bratcher had to say. Take a look. Okay, now this is an interesting point, and I'm glad we're showing this story to you right now. There was a lot of moments during this trial, and as we enter the conclusion of this trial, we want to recap where we are right now. There was a lot of times during cross-examination and even direct examination of certain witnesses where we got a little confused as to what the point of the witness was, what was the main overarching theme here. And the prosecutor said it really clearly that Wallis Bratcher is on trial for authorizing this behavior, for authorizing this payment, for Cindy Blitzer to continue getting paid and cashing checks for work she didn't do and then trying to cover it up. But is that what we saw during the course of this case? Randy, what do you think?
Well, the one thing that really strikes me, we just watched the clip of the prosecutor. Tell me at any point in time, to your earlier point, did he explain to the jury why? Now, again, we talk about this all the time. A prosecutor doesn't have to prove motive. But boy, it's really nice when a prosecutor can, because again, common sense, everyday life experiences. Tell me why. Tell me why Bradsher would do this. What was in it for him? It's interesting because, great, you don't have to prove motive, but when you start talking about what was in it for him, where is the crime? The prosecutor had a perfect moment in that clip just to simply say, this is what was in it for Bradsher, whether it was the fact that Bradsher's wife was working and got a big bonus and he wanted Blitzer to keep Blitzer's mouth shut. So, again, this cover-up, you take care of me and keep your mouth shut, and believe me, your wife will have a job and don't worry about it. She can go to school. That would have been so simple. Yet, I'm dying waiting for the prosecutor to simply give me the why.
And that's what's so strange. It's not like Pam Bradsher was doing the same thing as Cindy Blitzer. If she was not working and collecting paychecks, I could see this quid pro quo kind of situation. Just got to ask you, as an attorney, when you see this case of these two attorneys, and Craig Blitzer has already pled guilty to a misdemeanor charge, he is yet to be sentenced in connection with this crime, but when you see these two attorneys who are alleged to have been operating this scheme, what do you think about it?
It's so frustrating on a whole host of levels. First of all, one of the wonderful things about your show is that it really shines the light on the justice system for good and for bad, because viewers should say, wait a minute, you talk about a waste of taxpayer money? What the hell is this prosecutor doing? What is this prosecution doing, spending taxpayer money to go after this guy when, as a layperson, I can't figure out what the hell it is that he did now? Are you simply trying to take advantage of a climate where we have a basic mistrust of politicians, that we hate politicians and that we hate people in government, so we'll just convict this guy because we just don't like politicians and government people in general? No. That's horrifying to put this man through that, to make an example of him, just to say, you know what, we hate everybody in government, so let's put this guy on trial and destroy him. That's wrong. By the same token, it's wrong for government employees to take advantage, abuse the system, and in essence steal. But my God, make the case or don't bring it.
Randy, that was more well articulated. I wish I heard that from both sides in the case. That was actually, I hope everybody heard that. But here's what we're going to do. We're going to switch gears. We're going to take a break. And when we come back, we have to go back to the reality here, the reality of everyday life. And we're talking about the worst case, one of the worst cases here, a case out of Kentucky about a Marine who was killed in cold blood right in front of his wife. We're going to cover that case right after this short break. Welcome back to Law and Crime, everybody. We want to now talk about our other live trial of the day, the one that we're waiting for a live feed in. It's out of Kentucky, and it's about the death of a Marine named Jonathan Price, who was shot alongside his wife. His wife was shot in the leg, and she survived. She is a widow now. This young man was killed during a robbery gone bad. 2 men are charged in connection with his death, and these men are, you see them right there, and I just, you know, it's such a sad case when you hear about it, and you saw Megan in the courtroom yesterday crying, talking when the prosecutor was talking about this case. The 2 men are Quincinio Canada and Dewan Mulazim. These 2 men are charged with his murder. They are also charged with first-degree robbery and first-degree assault. It is alleged that 6 days before they went up to this couple and stole her purse and shot both of them, that they engaged in an armed robbery at a hotel and took 3 people by hostage, stole from them, and also took a gun from that one of the victims had on them. It is believed that that gun was used in connection with this shooting, the Jonathan Price shooting. But to help explain where we are in that case, and as we wait for the live feed, I want to play you a little bit of the prosecution's opening statement. This, again, is a perfect way to understand where we are in this case, what's happening, and what we can expect moving forward. Let's play that right now. So we know that the gun that allegedly was used in this crime was traced to another robbery that these men might have been in connection with. When you have that kind of thing where a firearm is used in multiple crimes and it's used to connect defendants, is that an avenue for the defense to explore, saying, hey, listen, you know, how can we track the evidence properly? Is that an avenue for the defense to attack? All right, well, that wasn't quite the prosecution's opening statement. That was me. But we'll jump to that in a minute once we have it ready. Let me bring back on Randy Zelin. This is a sad case. This is a really sad case. But the defense, in their opening statement, poked a lot of holes in it, or at least seemed to provide some holes in it. That when you look at that surveillance footage of these 2 men walking in the area, how could we know it's really them? How do we know these 2 men are the ones that committed this crime?
Well, anytime you have what we will call a circumstantial evidence case, and let's make sure that we all understand the difference between circumstantial evidence and direct evidence. Direct evidence is simply you saw it, you tasted it, you touched it, you heard it. A witness comes on and says, Randy Zelin was on Law and Crime. How do I know that? I saw him. That is direct evidence from a witness. Circumstantial evidence is where you don't have that eyewitness, for example, but you have other evidence that would put Randy at Law and Crime, even if nobody actually saw me on. And with circumstantial evidence, think of it like links in a bracelet. So you have one end of the bracelet to the other. Where you ultimately want at the end of the bracelet is Randy Zelin was on Law and Crime. And you start linking evidence. Evidence as simple as, okay, do I have cab records that Randy went to Law and Crime Studios? Did anybody have a conversation with Randy that wouldn't be hearsay? What are you doing today? I've got an appearance on Law and Crime. Maybe somebody saw me leaving the building at a time when the show would have been over.
Right.
Circumstantial evidence is just as strong. It's the same as direct evidence. So here you have no direct evidence of this actual killing. Of course, you've got the wife, who, thank God, survived, but you don't have any other eyewitnesses, objective eyewitnesses. You don't have necessarily confession, though there is some talk about somebody shooting a mouth off, but nothing to law enforcement. So now they have to piece it together. And part of the problem here is that the defense's position, as you said, they're going to talk about sloppy police paperwork, sloppy police procedures, that the police should have looked at this, didn't. The police should have spoken to this person, didn't. The police should have done this DNA testing, didn't. The police did DNA testing, it wasn't them. The surveillance video doesn't show distinguishing characteristics. We talked about reasonable doubt earlier. Reasonable doubt is, do I need more information? And the defense hopes to take all of that holes, the poking of the holes, and make it enough that the dam actually breaks, because there are so many holes that the floodgates open.
Well, let's start off with the prosecution now about what they said in their opening statement. Again, it provides a narrative of where this case is going and what they believe ultimately happened to Jonathan Price. Let's play that for you right now. Okay, so that was some of the prosecution's opening statement there in the murder trial of a Marine, Jonathan Price, and also the assault of his girlfriend, his wife, Megan Price, who was shot in the leg as a result of this really horrible robbery attempt gone bad, or at least that's what the prosecution is alleging. But let's see how they did. I want to bring back in criminal defense attorney Randy Zelin. How do you think the prosecutor's doing it, laying out the story of these two interconnected stories? We're talking about a murder, and then we're talking about a robbery 6 days before and trying to tie them together.
Opening statements are supposed to be a very just cool, calm, and collected roadmap for the jury, because there is no evidence in the case yet. Therefore, the prosecutor can't talk about evidence. All a prosecutor is supposed to do is talk about what the evidence will show. So typically, an opening statement is simply a dry run for the jury. So this way, when the case is proceeding, they'll be like, oh, yeah, that's right. I know what's coming now because I remember the prosecutor spoke about it. It's kind of like driving somewhere. Once you've been there once and you see some of the landmarks, you know where you are. That's what an opening statement is supposed to be. What I found in watching the clip with you and your viewers, a couple of things jumped out at me. First of all, just as a matter of practice, you don't read from an opening statement. And I found myself, at least, looking at the prosecutor and saying, boy, how much do you really believe in this case? How much do you really know your case? You keep looking down at your notes. Now, I'm not suggesting that a prosecutor should give an hour or 2 hour opening statement and just do it on the fly. But you don't actually sit there and look down while you're talking to the jury. You've got to know your case. You want to come back to your notes and check off, make sure you covered all your points. But I found that weird. And I'm sure there's at least one juror that also was like, wow, you really know your case? I found that there was too much time spent on this robbery. So immediately, at least for me, I'm already getting confused. And as I sit here, I say to myself, boy, that's kind of weird. How are they going to explain the fact that someone's holding a gun to these people, yet you're telling me that the gun that was used in the homicide is a gun that was stolen? Why would you steal a gun if you already had a gun and then use a different gun? So already I'm wondering, but of course, once we get to the defense, we can highlight those holes that the defense is going to do its damnedest to poke into the case, to have at least one juror say, wait a minute, I can't convict these guys.
Yeah, this case has been taking years to finally get to a trial, and it's finally here, and that's what we're reviewing. We're keeping a careful eye on the courtroom feed. As soon as it starts, we'll make sure to jump into it. We want to be live in this case. We don't want you to miss anything. Let's continue playing you some more of the prosecution's opening statement, and this is, we're going back now to the crime scene. Let's talk about what happened when Jonathan was shot. Take a look. That was the prosecution's opening statement in that case about a Marine who was killed in Kentucky. And it's a really, really sad case, one that we never like to see. The defendants are Quincinio Canada and Dewan Mulazam. These two men are charged, as you heard, with murder, first-degree robbery, and first-degree assault. And this is a death penalty case. Let's bring back in Randy Zelin. How much is it a problem for the defense that the victim here, there's several victims, the person who was killed was a Marine? How tough is that for a jury, to get a jury that is not tainted in some way? Because obviously murder is horrible and wherever you go, but here to have a Marine who's killed in Kentucky, this sounds, I imagine it's probably very tough to get a jury that doesn't want to, that's unbiased.
It shouldn't matter at all. Hopefully, from a defense standpoint, the defense spent a fair amount of time with the jurors talking about it doesn't matter that the victim was a Marine. Every life is equal. No one's life is better. There's not a particular statute that killing a Marine is worse than killing a carpenter, that's worse than killing a school teacher or a stay-at-home parent. So as a legal matter, you've got to make sure that you get promises from every juror that the mere fact that the victim was a Marine is not going to factor into whether or not the prosecution has proven its case beyond a reasonable doubt. You raise a very interesting point, though. What did we see during the prosecutor's opening statement? That picture of the victim in his Marine outfit. I would have objected. I would have yelled and screamed until the cows came home. Why in God's name is that allowed to be up there? First of all, it's not evidence yet, number one. And number two, it is extraordinarily prejudicial. Why, in the course of a prosecutor's opening statement, do the jurors have to be staring at the victim in his Marine uniform? To me, that is unfair, and it is something that really should have never been permitted to have been in the courtroom. The other thing that I found also weird about the prosecutor's opening statement was she made mention to the jury of the defense's defense, or the theory of the defense. The defense has no burden of proof. These two gentlemen could sit there and read the Kentucky Gazette throughout the trial, and that could not be used against them. So for the prosecutor to be getting up an opening statement and saying to the jurors, reject the defense's contention that they're not responsible, reject the defense's contention that it wasn't them and that it was somebody else, to me, you're already starting to talk about reversible error and an appeal, because what is the prosecutor doing commenting on a defense that's not even a defense yet?
Well, let's talk about the defense. We're going to play you the defense's opening, but it's not just any defense opening. There are several attorneys here, and even though these two men are being tried together, the attorneys for Quincinio Canada chose to waive the right for an opening statement, while the attorney for Mulazam, Kim Green, did provide an opening statement. What do you think is going on there?
Well, you have a couple of interesting things going on. Why does the defense waive an opening statement? You do it for two reasons. Number one, it's kind of a subliminal message to the jury, which is, you know what, I'm not really worried here. I'm going to let the prosecution put on their case. I'm going to cross-examine the witnesses and stay tuned. There's another reason why you do it. You don't want, as the defense, to paint yourself into a corner, because if you give an opening statement and you offer an explanation, if you offer a defense, you run the risk now of alienating the jury if it turns out that you can't keep the promise that you made in your opening statement, that the proof won't show this, the proof won't show that, or we're going to show you this, and if God forbid you should say, we're going to put on a case, you're going to hear from us. And then as the trial unfolds, things happen, and you're like, oh, God, you know what? You can't do it. Now you're screwed because you've left the defense. Wait a minute.
Right.
Obviously, you're going to lose because you promised me I was going to see things, and now you're not showing me them.
That's an interesting point. I don't think I've thought of that before. That's really interesting. So we'll have to see what happens. But let's start off with Kim Green, the defense attorney for Mulazam, talking about the lack of DNA, the lack of evidence really implicating these two defendants in connection with this crime. Let's play you the defense's opening right now. Okay, so the defense attorney, Kim Green, who represents Mr. Mulazam, is throwing out a lot of doubt there for the prosecution's case. But let's dissect it a little bit more and see what she's saying back here with Randy Zelin. First thing she said was that if you look at the victim's fingernails, so Jonathan Price, the Marine who was shot, he has DNA under those fingernails that do not link to either of the defendants. What do you think about that statement?
To the extent that that can be backed up by the defense, and we can pretty much figure that it can be, because as part of the discovery process, the prosecution would have turned over results of scientific tests like a DNA analysis. And if, in fact, there is a DNA analysis that says on a piece of paper, hey, we did an analysis, there were something under the fingernails that came back human, and it wasn't either of these defendants, that is a compelling piece of evidence. Now, of course, the prosecution is going to say, wait a minute, there wasn't a fight here. there was a gun involved. So there would be no reason for any of the DNA of the defendants to be in the fingernails. This is not like a rape or a fist fight where in defending yourself, oftentimes you'll find DNA evidence under someone's nails. But what automatically happens now, the prosecution has to now play into the defense and react to, wait a minute, you have scientific, completely objective proof that isn't helpful. Distraction.
Yeah.
So a lot of things were said, but I will tell you, to me, the game changer was the allegation of the photoshopping. If the defense can back up the fact that the detectives photoshopped a photo to get a positive ID, these two are not getting convicted. Conversely, if the defense can't back that up, and it's interesting because there was probably some kind of a pretrial hearing that goes into an identification procedure. If the defense can back that up, man, this prosecution's in trouble.
Well, adding to what you said, Kim Green said that eyewitnesses didn't mention and surveillance videos don't show gold teeth or facial tattoos, which are the distinguishing characteristics of the defendants. That's a problem. That's a problem for the state.
Well, of course, we don't know just how good the quality of the cameras were, whether or not the photos of the video is grainy, if it's black and white, if it was taken from a distance. It may very well be a plausible explanation that the quality simply is not there. Conversely, if it's good quality and you would otherwise be able to see a tattoo, and we could already see just in the courtroom that the defense took the care to make sure that one of the defendant's hair was pulled back.
Right.
So you could easily see the tattoo by the eye and the tattoo on the neck. So that will come down to the jurors being shown the surveillance. And man, once again, if it's clear and easily seen and there's no tattoos there, prosecution's in trouble.
Okay, let's see a little bit more of the defense's opening, poking holes in the state's theory and saying there really is a lack of evidence against these two men. Let's keep going. This is the defense's opening statement in this Marine killing case out of Kentucky.
They came
That is Kim Green hammering away at the prosecution's case, in this case out of Kentucky that we are covering, and she represents one of the defendants, Dewan Mulazim, and basically saying the evidence presented against these two defendants is not very strong. We're going to talk about that case in a minute, but I want to update all of our viewers about the Wallis Bratcher case out of North Carolina. As you know, we're carefully monitoring this case about a district attorney who is on trial for allegedly operating a criminal scheme to hire another district attorney's wife and paying her for a no-show job, paying her $48,000 for work that she didn't do. He faces 6 felony charges and 1 misdemeanor count. The jury is now in deliberations. Instructions have been read. We are on verdict watch. As soon as we have a verdict, we'll make sure to let you know. It could be 5 minutes, could be 10 minutes, could be an hour, could be a few hours, could be a few days. Who knows? We'll have to wait and see. But stay tuned here on Law and Crime, because I really have no idea which way this is going to turn. No idea. This man faces 18 years in prison if convicted of all the charges. So we'll keep you updated about that case. But let's switch gears now, talk back to the Kentucky case. These two men, Quincinio Canna and Dewan Mulazim, are both on trial for the murder of Jonathan Price, as well as first-degree robbery and assault of multiple victims. So I'm back here with Randy Zelin, criminal defense attorney, our great guest for this morning. This was a big thing that she threw out, and I want to talk to you about it now, that the gun that was found, the police that recovered this gun, this suspected murder weapon, was found in the hands of a different individual, Antonio Fry, and the police failed to, according to her, the police failed to consider him as a suspect because they had already settled on the two defendants. That is a big claim. What do you think about it?
That is a very big claim. It's no different than my cell phone. If you're accused of stealing my cell phone, it's one thing if the police recover that cell phone from you. That's easy. But imagine if the police recover the cell phone from somebody else.
Right.
How the hell are they going to explain that? What they now need to do is link the seller to you. But I think if we take the defense at its word, the police had no interest in taking a look at the actual person who had the cell phone, who had the gun last. That would be pretty important, you would think. So, yes, you have that acute issue. But what else did we see in the defense opening statement? We saw a theme. We talked earlier about prosecution doesn't have to prove motive, but boy, it's great when they can. It's also great when somebody comes up with a theme. And Miss Green developed a theme. And what was that theme? It was the old story from those viewers who remember the days of The Odd Couple and the episode about assumptions. And what happens when you assume? You make an ass out of you and me. And you heard Miss Green talk over and over again about assumptions made by law enforcement. What she was really trying to say, there's an old theme that we use in the defense. We take a target. Under normal circumstances, the target's up on the wall, and you fire the arrow. And where the arrow lands, that's where it lands on the target. However, in this case, what Miss Green was basically saying was law enforcement shot the arrow first. Then they drew the target around the arrow, and the bullseye are the two defendants. Mm-hmm. That's what she's really trying to say here. And as she said, to her credit, ladies and gentlemen, she's almost saying it's understandable. High-profile crime. High-profile victim, if you will. A Marine. We're in Kentucky. We take our men and women in uniform. We hold them very dear to us. This was a big deal, this case. As you said earlier, it was a horrible crime. The public demanded justice. What does that really mean? They demanded defendants. They demanded someone to be held accountable. So law enforcement made a knee-jerk decision, made an assumption, and they sure as hell weren't going to say, oh, you know what? We may have made a mistake. We may have jumped the gun, as Johnny Cochran said. We may have rushed to judgment. So we're going to ignore anything that doesn't fit with our story. We're not going to talk to the lawyer who may have had someone with a tip. We're not going to talk to the seller of the gun. We're not going to worry about a misidentification. We'll deal with the video that doesn't show the tattoos because we have these guys and the public wants us to convict these guys.
But now prosecution's eventually going to have to talk about this at some point in the case during cross-examination or maybe even in their closing statement. Now they're forced, we didn't hear anything about this. I didn't hear anything about Antonio Fry in the prosecution's opening statement. I didn't hear anything about this photoshopping. I didn't hear anything about this. Now they're forced to answer it. And I think we all need answers for all these claims put forward by the defense. If they're true, not true, we'll have to see. This is really the beginning stage of this case that's taking years to finally get to the courtroom. And maybe we'll talk a little bit later on about why it's taken so long to get to the court, because it happened so many years ago. And now, finally, the family is sitting there and waiting to hear what happens. And again, the defendants themselves have been waiting to finally see what happens. So we will cover these cases in a minute. Again, we're in verdict watch in the Wallis Bratcher case. We're carefully monitoring the feed in this case out of Kentucky. But before we cover any of our live trials right now, I want to play for you the top crime stories of the day here on Law and Crime. Take a look. Thank you, Anthony. You can go to lawandcrime.com to follow more of those stories as well as other top crime and legal stories of the day. But let's talk a little bit more about that Florida case about the man who was accused of killing his pregnant wife. Back here with Randy Zelin. Been great talking to you all this morning. It's been great catching up with you on all these stories. And we talked a little bit about this one from before, but I want to bring it up again. Do you see in your experience, if this is all true, that a lot of suspects or a lot of defendants get caught when they're not killing the person, but all the attempt to try to cover it up or dispose of a body afterwards?
It is very common. What we find is it's not what you did that gets you jammed up, it's what you do afterwards. So the short answer is absolutely. So far more often than not, where someone ends up getting caught, it's what happens afterwards. It's either the cover-ups, it is going back to the crime scene. It is talking, because you can only talk yourself into trouble as a suspect. It is maybe doing something else afterwards, and I hate to say this, and if anyone is watching and thinking about committing a crime, the cautionary tale is, if you're going to commit the crime and move on. Don't do anything afterwards. Don't do it again. Don't try to cover it up. Don't go back. Don't talk about it. And again, disclaimer, I'm not for 1 second advocating or helping someone to commit a crime. But again, to your point, yes, it is so often what happens afterwards that ends up putting the bow on the case and someone in handcuffs.
So weird, Randy. Our message board is blowing up. People want to talk to you now. I have a lot of questions. I don't know. Really,
there's no attorney-client privilege to talk about a future crime.
A lot of 555 numbers. Weird, strange. Question for you. Brought it up earlier. Want to talk to you about it again. If you were representing this guy, comes to you and said, "Listen, here's what happened. My wife was disrespecting me." That statement. What's the first thing that goes in your mind if you hear that?
My knee-jerk reaction, if this was a Rorschach test?
Yes.
Cultural. There are times when I'm representing a client, and that client is not from the United States and is from a different country. And in a different country, what we may not find to be acceptable behavior here is perfectly acceptable behavior where that person comes from. It may be for a religious reason. It may be for a cultural reason. It may be an upbringing thing. But there are certain things that go on in the United States that are not cool, but in another country are either cool or accepted or not exactly focused in on. So that's probably where I would start. I would want to know my client's upbringing, my client's experiences, whether or not what my client did here, if it were done in my client's home country, it would be okay. And I would probably develop as much evidence as I could about that, not necessarily for an acquittal,
right,
but to go to a prosecutor and attempt to negotiate a more favorable disposition, because odds are, and maybe I would make a motion and try to convince a judge, look, in order for my client to be convicted, my client has to have had knowledge and my client has to have had intent. And both of those issues are skewed because in my client's home country, what my client did was not a crime. What my client did would be acceptable. Now, I may not win that motion and get a dismissal, but if I can get a prosecutor thinking, okay, maybe there is a juror there in that box at the trial who may say, you know what, I got a problem with this. I don't agree with it, but okay, I want to try this case again. So maybe that sets the groundwork for a more open discussion about a resolution to the case.
That is interesting. Maybe, I don't know anything, I don't know too much about this guy, I don't know anything about it, but that is an interesting way to maneuver that, Randy. So let's see what happens with that case. We'll always update you about what happens. Now, I am keeping a very careful eye. I see the courtroom feed right now out of Kentucky for the Jonathan Price. He's the Marine who was murdered or who was killed. And the question becomes, who did this? And two men are on trial for his murder, Quincinio Canada and Dewan Mulazam. We're believed that they are nephew and uncle. That is their relationship, who went on a crime spree together. That is what the prosecution is stating. As soon as that feed begins, and we're waiting for it for trial to start up, I want to play you a little bit more of the defense's opening statement from yesterday, where Kim Green, who represents Mulazam, just really kept going into the prosecution and the detectives and investigators in this case, saying that this is tainted. They went after these two men even though there was evidence that they didn't do it, because they made assumptions. They made assumptions about them, and these were unproved assumptions. Let's play you a little bit more of the defense's opening statement. Okay, so we are cutting out of that prior feed that was the defense's opening statement in this Kentucky case, because we are live in that very case, and that is the picture. That is a live feed into the defense's table. That is the defendant in the blue shirt, one of the defendants, Dewan Mulazam, as well as the guy, I believe it's a white shirt, maybe an off-white shirt. You can't see his face. That's Quincinio Canada. Those two defendants are on trial for assault, robbery, as well as the murder of Jonathan Price. There was a motion being made in the court. We're waiting for the audio to begin. As soon as we have it, we'll make sure to start. I'm back here with Randy Zelin. Randy, we are continuing the case today. I'm very curious to see where it will go. We were watching a little bit more of defense attorney Kim Green's opening statement. She really had a lot of things to say, and then she was talking about cell phone records and cell phone towers, excuse me, and how the area might not be as big as we imagine. What did you think of that?
Well, let's take a step back, and I think the one thing that Ms. Green might have wanted to do was just spend a little bit more time talking about why she's talking about the cell phone records. Common sense would dictate that one of the ways that the prosecution will try to put the defendants at the scene of the crime is by using cell phone records. Without getting too complicated, there are these things called pings.
Right.
And that is how you put someone, assuming that they're holding their phone, at a particular place. But what Ms. Green was trying to say was, wait a minute, that doesn't put the defendants 50 feet or 100 feet or 25 feet. It could put the defendants 10 miles.
Yeah, well, maybe we'll get an explanation right now. This is a new witness on the stand. I believe it might be a detective. Perhaps he will talk about the cell phone evidence in this case. Let's go live into Kentucky. Okay, everybody, so this is a new witness on the stand who is a detective in the, I believe, the robbery homicide division. We are going to wait. He's providing his credentials, background. We'll jump right back in a minute, but before we do, have to sign off my very special guest, Randy Zelin. Thank you so much for joining us today.
Always a privilege. Thank you.
Thank you. Okay, everybody, we're jumping back into the Kentucky courtroom. Two men are on trial for the murder of a Marine. Let's go.